welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about divorce and family law litigation and everything that goes with that. I want to welcome in my co-host, Jesse Barrientos. Jesse, welcome to the show.
Thanks, Dave.
Jesse, you've been practicing divorce and family law for a number of years. You handle it in DuPage County, Cook County, and all the surrounding counties. Is that correct?
County, yeah, exactly.
And importantly, you've co-authored a book, Divorce and Family Law, that we're going to talk about tonight. Who has the legal right when things go terribly wrong? What was your process of writing this book?
Basically, we just wanted people to get the idea to have just a brief, no-nonsense information as to kind of the things that happen during a divorce. Questions about custody, questions about support, and those things, so that people, when they go in, whether or not they hire us or not, that they'll be a little bit more informed and they'll be able to make a better decision.
And your book has helped thousands of people feel more comfortable with this very difficult process of going through either a divorce or having family law issues, which we're going to get into: custody, support,
right,
visitation, division of property. Let's talk about the biggest issue involving children in custody battles. How do we litigate a custody battle from start to finish in simple terms?
It's very difficult. In fact, judges don't like to do that either. If we can separate the whole issue of the property and the division of the marital assets and liabilities from the custody, visitation, and support issues, then, if we're just looking at just purely the custody issues, there are many different ways to kind of look at that. Initially, what will happen is somebody will file a petition for temporary and permanent custody.
As part of the divorce proceeding.
As part of the divorce proceedings, right.
So it's within this divorce case
Correct.
That's already filed, someone is filing a petition for temporary custody, correct?
That's right. Exactly right. And so,
and what's the court's reaction to this?
Well, they'll file it, and unless it's an emergency, because sometimes they have an emergency temporary motion to transfer custody or for temporary custody. The courts don't like to do that either. They like to maintain the status quo, and the status quo is what's going on at the time. So let's say that the mother has the children and has had the children, and the father comes in and tries to get temporary physical possession, unless there's a very good reason or an emergency reason, or the children are in harm or in danger, that's most likely not going to happen.
Right. There's a lot of misinformation out there. People believe that whoever has custody, the non-custodial party, has no rights whatsoever to visitation or anything. And I think one of the things the court likes to do is send them to mediation so that they can become educated on whether or not custody really means what they think. Because oftentimes they don't understand that custody does not mean the non-custodial party has no rights.
Right, that's true. And in fact, the courts will, if there's a custody or visitation issue, the very first thing that will happen, well, they will allow the other party to respond within generally 28 days or so.
In writing, respond in writing.
In writing, respond, and they'll set it for status or hearing. We'll talk about some of the other intricacies and the other processes and steps that generally have to take place in that. But they will send them to mediation. Now, mediation is a wonderful process, because the mediation that you engage in is what they call facilitative mediation. And that means that the mediator is the person who is in control of the process, and the parties, the litigants, are in control of the outcome. And essentially, it's better for the parties to be able to determine what the outcome is going to be than to allow the judge, who can only listen to a thumbnail sketch of the situation in the parties' lives at best, and then make a decision based upon the best interest of the children. And again, we'll get into those other things, but right, mediation, I want to stress, is not only is it required, but it's important. It's important for people to go into that process with an open mind, with an eye toward resolving it, because I'm going to tell you that if you don't, it's going to be a long, protracted, although Supreme Court rules say it has to be done within a year and a half, there has to be a determination with respect to custody on those issues. But if you go in with an eye toward resolving those issues, a lot of times they can be worked out. And sometimes the issues of custody, sometimes there's deeper problems that a really good mediator will be able to ferret out and be able to let the parties kind of bring up to light.
Sure.
And they'll express their concerns. And again, the parties are the ones that will or should, in a successful, real facilitative mediation, be able to come to an agreement.
Great. The most common form of custody is joint custody for decision making, not joint physical custody. Can you explain to the audience what joint custody really means to the parties?
Sure. There's most of the time you have a custodial parent and a non-custodial parent. Custodial parent is the parent that has physical possession of the children most of the time. Non-custodial parent is the one who doesn't. Joint custody means that the non-custodial parent, the parent who doesn't have the physical possession of the children most of the time, is going to have a say-so in the upbringing of the child or the children's lives, in their schooling, in their religion, in kind of the day-to-day activities. That's only, though, for people who can get along.
Right. And this is all flushed out in a joint parenting agreement that sets out the rights and obligations and how all this works.
That's correct. And it's pretty extensive. Different attorneys do them differently. Mine, I try to do very detailed and extensive. And although you can never really prepare for every situation. But we try to make it specific, because people are going to go back and run to that. But if two parties are truly, and they should be, as it relates to the children, there's no reason that you're going to be in each other's lives well beyond the children's 18th birthday, and so you might as well make the best of it. And so your idea and your focus should be on nurturing your children and doing the best for them. So if you guys get along, there shouldn't be any reason why it won't work.
Right. The court also has an interest in making sure that agreement is, first, not unconscionable, and two, that it's detailed enough so that the parties are not back before the court in post-degree litigation after the divorce is over.
That's correct. In fact, one of the requirements is that the joint parent agreement have a mediation provision, which basically allows or provides that the parties have to try to work it out first before they can file a petition in court to try to do whatever it is they're trying to do as it relates to the children.
Yeah, and the agreement also has to be reviewed annually.
It does. A lot of them I've seen where it says, okay, they'll review it annually. Actually, it's
January 1st.
Right. It's an ongoing thing. I mean, again, it's just whatever's laid out there, and there's a specific visitation schedule and everything else is the fallback. That's what's required. However, the parties can agree to do anything they want to do. So, for example, if one party has a vacation that's not in accordance with their agreement, they can switch off, or they can switch weekends, or they can have the kids at a different time, and that's what it's about. It's about making the children as comfortable as possible, not about convenience for the parents.
Right. So the document is not so rigid that it can't be modified, at least by agreement.
Right.
What about this parenting class requirement? Parents who have minor children going through a divorce, whether there be a custody battle or not, are required to take a parenting class county by county. What is the purpose of this?
Well, I think the idea behind that is they want to educate the parents in terms of,
Isn't this government intervention?
Well, I don't know if it's government intervention, Dave, but I do know that information can't be bad. And I think that a lot of times, again, what I said just a few minutes ago, that sometimes people try to do things for their own convenience. It's not that going to a parenting class is necessarily going to make you a better parent, but what it's going to do, hopefully, is to educate you, give you some ideas about what the child is going through, because there are psychological implications for the children when they go through this process.
I'm just worried about the slippery slope. What about a class before they actually get married, a class before they get pregnant, a class before everything? I mean, at some point, it's enough with the class and we have to live our lives. But back to this.
Well, wait a minute. I was going to say, if it were as expensive to get married as it were to get divorced in most cases, people might take another look.
By the way, I hear that a lot when I quote a divorce fee, or when they call around and get fees. They often say, it didn't cost that much to get married. Well, that's right. That was just a license fee.
Right.
And the preacher can do it, or the clerk can do it at the courthouse. But divorce is a whole different ballgame. I think court costs are running approximately $500 now on average throughout the counties, and that's not including the court reporter fee that's due in some counties at the end of your case. But let's get back into litigation.
Sure.
Let's get to the crux of custody. What is this best interest of the child standard that the court adheres to?
Well, the court wants to make sure, again, that everything is in the child's best interest. And so the way they do that, no judge really wants to make a custody determination because a judge has a whole bunch of cases in front of him. You never know what's going to happen. So a lot of times what will happen, the court can do it on its own motion, or either one of the parties can petition the court and ask for a GAL, which is a guardian ad litem. It's kind of beyond the scope of our show here to talk about the different things, the attorney for the child, the different kinds of
the
guardian ad litem.
Let's talk about the result that the court is trying to bring about.
Well,
what is that?
The guardian ad litem is essentially an attorney for the child, and basically that person is going to investigate and to talk to each of the parties, going to talk to the children, it's going to talk to people in the school, going to talk to other people, and they're going to recommend to the court, and very often that's what happened. It's a guardian ad litem is appointed with respect to them making an oral report. They don't have to. It depends on where you're at and the circumstances.
Somebody's got to pay that guardian ad litem or child representative.
Right. Generally, it's split between the two parties, although
So this is another burdensome expense that the parties are putting themselves through by not being able to agree on custody.
That's right, and sometimes it'll be in proportion to what the resources of the parties are.
So and if there's one breadwinner, that means that one breadwinner is paying both his side or her side as well as the other party's side.
Most likely that's what's going to happen, or it's going to come out of the marital estate, which is the equity in the home or some other place. But anyway,
if there was equity.
If there was equity, true enough, in this economy. But essentially, the guardian ad litem's job is to make a recommendation as to what's in the child's best interest. And I'm going to tell you, for the most part, the court is probably going to hold what the guardian ad litem is essentially the right hand of the court, and what the recommendations are that the court most of the time is going to pay great heed on, and that's because the judge can't get out there himself or herself and do that kind of investigation. And
wouldn't that be great if they did?
It would be very interesting, but they wouldn't be able to have and hear all the cases that they do. There's just simply not enough time.
They would really be earning their money at that point.
That'd be different for sure.
Let's talk about the after effect. Once custody is established, there's issues that arise where one parent doesn't agree with how the child's being raised. Can you ever change custody after it's been determined?
You can, but before we get to that, I'd like to mention the other scenario, and again, either party can do that. It's what they call a 604B evaluation, which is a psychological evaluation to determine the best interest of the child for custody or visitation purposes. And what will happen is everybody will go to the psychologist, and they'll do the psychological tests, and the psychologist will make a determination as to what's in the child's best interest. Now, it gets even better. I can tell you that can range anywhere from $4,000 to $8,000 or $10,000.
Right.
Now, if you get a recommendation back from a 604B, and that's essentially the court's
it's an expert.
It's the court's witness essentially. And essentially one party's not going to like what that person is going to say. Okay,
right.
And then they can get their 604.5 evaluation, which is their own expert, and they're going to have to pay for it. But the statute says that the other party may be required to pay for some of that, and that expert is going to go. You're going to go through the same thing, and they're going to make a recommendation. So, if it's the same recommendation, well, it is what it is. If it's contrary recommendations, then the court battle is just going to be about who is the better expert, who did the more detailed job, and it's going to be about finding, what this expert did and what that person didn't do and how well they didn't do it or did it or anything like that.
But importantly, this expert that you're talking about is only a piece of evidence. The court does not have to go with that expert's opinion.
Absolutely.
They can rule contrary to that expert's opinion.
They sure can.
And shock everybody. Or they can do some combination of the two.
Right.
But it's very important to note, though, if once custody is established and it's in writing, it's part of an order, it's not that easy to change it. Not quickly.
No.
Explain that.
Well, after not a temporary, after a permanent custody order, there is within the first 2 years, if you're trying to change custody, let's say the wife was awarded custody and now 6 months later, a year later, the husband wants to try to get custody and goes in on a petition, and he can. And by the way, you're going to go through the same process we talked about: mediation, possibly a GAL, possibly the evaluations. It just depends. They have to prove endangerment by clear and convincing evidence. So that means it's a very hard burden to show endangerment.
Well, let's say mother is smoking pot and she has people over and they're doing prostitution out of the house and the child is living there.
Right.
Would that be a basis for endangerment of the child?
I sure think that it would be. And then you have to prove it, again, by clear and convincing evidence, which is a step. We have different levels of evidence. We have by a preponderance, which means more likely than not. More than 50%. We have in the criminal cases beyond a reasonable doubt. Okay. And then somewhere in between there is the clear and convincing. It's a higher standard.
Yeah. I have found in my practice, Jesse, and you might concur with this, the people who fight over custody the most are the ones who cannot afford it based on the current system that's in place. It's not designed for average people to fight for custody. It's for very wealthy people to fight for custody and blow all their money on experts and court fees.
Yeah, it is extraordinarily expensive to have a custody battle. And, you know, there's different reasons why people do it. People do it because legitimately they believe that it's in their best interest. They want their children. Unfortunately, though, sometimes it's because I either want child support or I don't want to have to pay it. And that happens a lot, too. Sometimes there's unequal bargaining position, and you can go in and try to, you know, get attorney's fees to level the playing field. But what will happen is, you know, you're going to continue to go and battle. And if there is any marital assets, I can tell you that's going to go to the attorneys, and that's going to go to the experts and to those other folks that are going to be involved.
Let's move on to another issue in divorce litigation or family law litigation, and that being visitation. Whenever there's a judgment for dissolution or a paternity case, visitation is set out in writing as part of the order. And what happens is often, Jesse, one of the parties is either not exercising that visitation or one of the parties is not allowed to exercise that visitation. If you represent somebody who has visitation rights and they're being denied, let's just use the case where the mother has the child and the father has visitation rights, and he's being denied, and he comes to see you, what can you do for him and how?
Well, I mean, first, it's important for people to know that there is basically a statute. It's against the law for someone to deny visitation rights, and you can go to the police station. They can go, and it really depends. In my experience, and what it is essentially is they'll write a ticket, and then if that happens a couple of times, then it turns more serious. But my experience is that the police, you know, just tell the folks, hey, listen, you know what, it's a family law matter. You know, go and take care of it. So that's what I've seen in most of my experience. But
okay. So I'm at your office. I want visitation. What are you going to do?
If you've been denied visitation, then what we will do is most likely is to file what they call a petition for rule to show cause. That's how you enforce an order. If the order that was entered says that you get visitation on these specific days or these specific times, and you've been denied visitation without cause. Now, I say without cause because if you show up and you're drunk or otherwise impaired, you know, that would be a good reason for the mother not to give you visitation.
In this case, I'm calling up at my scheduled time. I want to see if the child's available. I'm coming by. I'm in the driveway. There's no answer at the door. They're not there.
Right.
What do I do?
Well, again, we need to explore, presuming that she's really willfully denying your visitation, not that, hey, the child was sick and they brought him to the hospital or some other kind of situation like that. Okay. You know, what we'll do.
Well, let me give you a narrative here.
Sure.
She's unhappy with me. I'm just using me as the example here because I am not paying child support pursuant to the statute, pursuant to the judgment. Mm-hmm. So to punish me, so to speak, because I haven't paid child support on time, maybe I'm having a hard time at work, she's depriving me of the visitation and holding one against the other. Do I have a cause?
You do, and so does she. Those two, you know, paying child support is separate from, you know, the rights of visitation, and the rights of visitation are separate from paying child support. You can't, well, I can't say you can't do that because people do it all the time, but legally, you can't, you know, use that against the other person. But I was talking about the rule to show cause, which is how you enforce the order. She'd be able to do that too if you haven't paid your child support. But I'm for the purposes of their...
Well, I think that's a great point that you made that people might not know, that the two issues, visitation and child support, are mutually exclusive. And by that I mean, if you're not paying child support, that doesn't mean you don't have visitation rights and vice versa.
That's right.
And a lot of people believe that one goes hand in hand with the other, and it's just not true. They're completely separate ideas, concepts.
That's right. So
that's a takeaway that I think people need to understand, that they do not hinge upon one another. Because I hear that all the time. I'm not giving visitation because he's not paying me.
And you don't use the children as a pawn just to satisfy your own, you know, vendetta or whatever it is that you're doing.
Okay, so back to this. You're going to petition the court for visitation rights.
Well,
or
for
rule to
show cause.
Because you want to get your visitation.
Right. And what will happen
What's the court likely to do?
Well, what will happen is we'll file it as long as it's a verified petition and we're there on the first day. Generally, the court, depends on which county you're in, but generally the court will issue a rule to show cause. And that means that the person, and this is very important, and it depends again with the local rules in which county you're in. If a rule is issued, that means then that the burden shifts. Instead of me, who is bringing the motion to show that the other person hasn't done it, the burden shifts to the other person to show why they shouldn't be held in contempt of court for disobeying the court order. And so what will happen is there will be there'll be a hearing date, and sometimes you'll settle it. But if you don't settle it, see, for lack of visitation, it's one of those difficult things because they have what they call a purge, which means if the court finds you in willful contempt, they have to give you an opportunity to purge yourself of the contempt. With child support, back child support, it's easy. Okay, we find that you haven't paid child support and you owe $5,000. Okay, here's the purge amount. You're held in contempt and you're ordered to be taken into custody, and that is going to be stayed. It's called a minimus for contempt. In other words, they're going to stay the order taking you into custody till this specific date, unless you pay the purge amount, which is pay the $5,000. That's easy because it's just a question of money, and either you pay the money or you don't pay the money. If you pay the money, great, it'll be discharged and you'll be fine. You'll still be looking at paying the other attorney's fees if he makes a petition for that, but you'll be okay. With visitation, it's a little different because you can't put the genie back in the bottle.
What's likely going to happen? What is the judge likely going to do when both parties are appearing in court and maybe the other party has filed a response?
Sure.
What is the court going to do?
What's probably going to happen is that you're going to get make-up visitation and you're going to have to pay for my attorney's fees.
Is there going to be a formal hearing?
Oh, there will be, yes.
Will the parties have to testify?
They will have to testify.
Will the child have to testify?
Generally, they don't want the child to testify. It's a bad idea to put your child against one parent against the other.
Can the court demand that the child testify?
The court could do what they call, depending upon the age of the child, the court could also do what they call an in-camera interview with the child.
Child's 11, let's say.
They can do an in-camera interview with the child. But
in-camera means?
In-camera means back in chambers where nobody else is there except the two attorneys, and it's kind of informal.
Away from the intimidation of a courtroom.
Away from the intimidation, away from the judge, judge stepping down off of his bench. I don't think that judges really like to do that unless they have to, although I know in Cook County there are a few judges that do it with quite frequency.
Right. Well, there could be some egregious situations
Sure.
where one of the parties is telling the child, you're not going to be able to see your father until he starts doing this, that, and the
Right.
other. So if that evidence did come out, that would be contemptible, I believe, on the part of the spouse who's denying visitation. Let's move on to something else, Jesse, that involves litigation, and that is asset dissipation. When you've got a married couple that are going through a divorce, and all of a sudden, the bank account that might have had $15,000 in it, joint,
Sure.
is down to $500. Where'd that $14,500 go? One of the spouses took it. What do we do?
Well, the very first thing that you need to do is to go in on what they call a temporary restraining order.
TRO.
TRO, and looking with an eye toward permanent injunction and an accounting. An accounting means that you're asking for the other person to have a specific accounting of each and every one of those dollars, where it went. Okay,
Right.
Because dissipation essentially means using marital assets for a non-marital purpose. It's a marital estate. Everything generally, as a general rule, everything acquired during the course of the marriage is marital property. There are exceptions. For example, if you received an inheritance and you didn't commingle it, and there's some other things, but generally everything acquired during the course of marriage is marital. So just figure there's just one big pot here. So this is the marital pie. And so if I use a piece of this pie for taking my girlfriend to Hawaii, obviously I'm using a marital asset for a non-marital purpose.
Right. Well, this example I set out, it's even worse.
Right.
Because everything was liquidated out of the account except $500, and there's no reason or no accounting for where that money
Right.
went.
What'll happen is we'll go in, and generally we can even do this what they call ex parte, which means without the other side. And what they'll do is they'll allow it for approximately 21 days, and they'll set a hearing date so that the other side can be notified. But during that time, it will be frozen. And then, depending upon what the evidence comes out, the judge will make a decision. But I can tell you, when you dissipate assets, what that means is that, let's say you dissipated $5,000 or let's say $10,000. Okay, all that means is, that the other party is going to get a bigger share if the court finds that it's dissipation from the balance of the marital assets. So let's say it's a 50-50 split on everything, but the court finds that you dissipated the marital assets by $10,000 and or $20,000, and your portion or her portion would be $10,000. So instead of 50-50, she'll get 50% plus the $10,000.
Here's the problem, though. If you're not dealing with well-to-do clients, that dissipation might affect the ability for the other party to make a mortgage payment, utilities, a car payment. It could really hamstring someone to the point where they need to get in court. and get that TRO and actually get the money turned back over so they can live.
We see that all the time. And you know, the other thing to look at too is sometimes they'll use the money for a marital purpose, which is to pay down bills. What can you really do about that? I mean, as long as it was used to, you know, for marital purpose, then you know it's probably not going to be found to be dissipation.
Sure. We've mentioned on other shows, specifically dealing with divorce and litigation in general, that it's always in your best interest, financially, emotionally, to try and resolve some of these issues on your own instead of throwing them all on the doorstep of the court, because that's where it gets difficult, expensive, and you take the decision-making out of your hands.
Right.
What kind of advice would you leave our listeners with, our viewers with, on how to handle these difficult times when maybe the war isn't over inside, but yet you want to be fiscally smart and try and take as much of the case into your own hands as possible?
It's always better for you to resolve something, and I would highly recommend that people go in. There's other things that you can do. There's private mediation even before you get to court to try to negotiate.
What is that? People need to know about this. What is private mediation?
What will happen is you'll go to an attorney who is a trained mediator, and both parties will come in and you'll essentially negotiate the divorce before you file the divorce. There's also what they call a collaborative law movement, where you'll go in and they have financial planners and other different kinds of people, other experts that are involved to be able to help you negotiate things so that when you file the divorce, everything gets filed at once and it's settled and you have control over the outcome.
Are you a trained mediator?
Yes. A divorce mediator for DuPage County.
In your practice, how has that worked with the mediation?
I'll tell you what, that has helped me with respect to my practice in terms of the way I deal with other people, in terms of the way I deal with other counsel. It's in everybody's best interest to resolve it. It's not financially feasible most of the time to argue over something. I had somebody argue over these little lawn stakes, the little lights that cost $62. Just the phone call and just talking about it costs more than the landscape lights. And so, you know, I'm not a furniture attorney.
It used to be toasters and steak knives. Now it's lawn lights.
True enough.
Okay. Well, Jesse, you are a co-author of the book, Divorce and Family Law, Who Has the Legal Right When Things Go Terribly Wrong? And it basically gives short, simple, concise answers to some of the most difficult questions that people don't understand in divorce and family law. And I would recommend that people pick up this book. They can contact you off the show to get a copy of it, if they're contemplating this or if they know somebody who's going through this kind of thing, just to provide some comfort, some understanding, and some knowledge, because this is one of the most difficult things, other than death, loss of a parent, that someone can go through in their lives. The stress that's involved in divorce or family law is just off the charts.
It is.
It affects people for years and years. Some people never get over a failed marriage.
It's true. A divorce is a death. It's the death of a very intimate relationship.
And again, Jesse, you practice in DuPage County, Will County, Cook County, all the surrounding counties.
Kane County, that's correct.
Okay, so wherever there's the case, you're going to be there.
Yes.
Okay. Well, Jesse, thank you very much for joining us.
Thanks, Dave.
It's been a pleasure. I think we've been enlightened on litigation involving divorce and family law. We talked about custody. We talked about visitation, a little bit about child support.
Yes.
And a little bit about asset dissipation, where one party takes assets away from the marital estate in an improper purpose. So thanks for joining us, Jesse. We'll see you next time on Legal Action. Take care.
Thank you.